there, coming on the air with breaking news. A verdict has been reached in this closely watched Karen Read murder retrial. We will go live to a Massachusetts courtroom where the verdict is expected to be read any minute now. Karen Read, of course, accused of killing her boyfriend by backing her SUV into him and leaving him for dead after a night of heavy drinking. Her boyfriend, John O'Keefe, a veteran Boston police officer, died more than 3 years ago. And since then, the case has captivated much of the country. Many crowds gathered outside of the courtroom as I speak here, all awaiting this verdict. Read's case has also prompted enormous scrutiny of law enforcement after misconduct allegations led to the lead investigator being fired, a critical focus of this trial as his text messages about Read came out during this trial and in the first one as well. All of this comes nearly a year after Read's first trial ended with a hung jury. That verdict not able to be unanimous. The jury there deadlocked. Let's go to the courthouse now first in Dedham, Massachusetts, where Emily Aketa, who has been covering this trial from the very beginning. Let's go to her first. Emily, what are you hearing about the court suddenly bringing everyone back in? We thought we had a verdict earlier in the day. Now we understand it's the real thing.
Well, Laura, it's been consistent with how this case has played out, legal twist after legal twist. And as word of the verdict coming in, you can see what happened behind me. Crowds of Karen Read supporters, the sea of pink behind me. They've closed down the road behind me, and they're now all waiting with bated breath for word of the verdict. They're facing the courthouse behind me. There's a media frenzy beyond that point. But just moments before that, at 2 p.m., they had called in the defense and the prosecutors to come back to the courthouse, and it appears the judge is now returning to the stand, and she's about to address the jury, Laura.
As she sits down there on the bench.
Mr. Foreman, on docket number 2282-CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you? No. Do you agree?
Yes.
Do all of you agree?
Yes.
Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Of?
Is not guilty or guilty of that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
Yes.
003, what say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty?
Not guilty.
So say you, Mr. Foreman?
Yes.
So say you all?
Yes.
Jurors, hearken your verdict as the court records it. You, upon your oath, say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise. Jurors, follow me.
You just heard the verdict there announced there live in court. You watch Karen Read hugging her attorneys tightly. Obviously an enormous relief for her. She has been cleared of the most serious charge of second-degree murder. The jury announcing that verdict of not guilty just moments ago. They're still walking through some procedural matters here, but again, not guilty on the most serious count of second-degree murder. The jury did, however, find her guilty penalty of one of the lesser included offenses of operating under the influence of liquor, but a far cry from what she had been facing, which was life behind bars. That is not the case now. Also clearing her of leaving the scene of an accident resulting in death, the third charge that she had been facing. Well, we'll wait to see exactly what else is being said there in court, but I want to bring in right now Danny Savalas, who joins me here at the table. Danny, you and I had followed this from the very beginning. We knew that they were sort of struggling with some of the jury instructions that appeared yesterday. They were asking a bunch of questions about what should happen if they were to acquit her on some, but not all of the charges. Here today, we, of course, now have the verdict of they have, in fact, acquitted her on the most serious charge of second-degree murder, obviously, which would have been an intentional killing. It appears, based on this verdict, that they bought into the defense's theories that there was no collision, and if there was, it certainly wasn't intentional, and she did not leave him there to die.
You're exactly right. This verdict is consistent with the defense's theme from the beginning, which was there was no collision. And if there is no collision, then logically the only thing she could have been convicted of is OUI or DWI or DUI or however your particular state describes it. It's essentially the same crime. So if there's no collision, Karen Reed essentially admitted in documentary clips that the jury heard, admitted that she probably shouldn't have been driving that night. There was plenty of evidence of her drinking at the bar on video, so much evidence of drinking that there was no surprise that the jury found her guilty of that. And in fact, I think that was a strategy by the defense to have OUI on the verdict form so the jury felt they could convict her of something. If they felt she did something wrong, that is what they could hang their hat on. And sure enough, it was a gambit that paid off for the defense.
Which is why you see the defense sometimes actually ask for those lesser included offenses to be available so that that very situation could happen. Because if they only had the choice of second-degree murder or manslaughter, they might think that those are their only options. And again, in the first trial, there was some discrepancy about whether or not they had to use the lesser included offenses or whether they had to convict on all. And some of the jurors reported, even after the first trial, of being confused. It'll be interesting to see what the jurors in this trial say was going on in that room. Remember, they've been deliberating, folks, since Friday. And we don't know, again, we're just gleaning this on what the note said to the judge yesterday, but there was some sort of back and forth on all of this, which is not unusual. You and I both know that's the whole point of deliberation. Right? They're supposed to hash everything out. They're supposed to hash out the evidence. They did have a question about the operating under the influence and the alcohol limit and what time of day they should be judging it on. They also had questions about whether they should be using her own video admissions because the prosecutors had the benefit of an enormous amount of things that she had said on tape in interviews since the last trial, and the jury was able to take in consideration all of that, and they still acquitted her on second-degree murder.
Yes, you could say the only evidence that really made this a close call for Karen Reed was the evidence she created, not only in her words at the scene of the accident, where she says, did I hit him or I hit him, depending on the evidence, and then later on speaking to documentarians and creating all this additional evidence that really formed in many ways the centerpiece of the second trial. So imagine the concern in the prosecutor's mind when the jury sends out a question, hey, is this video evidence of her making these confessions? Is it even evidence? That had to put some concern in their minds.
Okay, I just want to go to the courthouse there in Dedham because, as I mentioned earlier, there is an enormous crowd gathered. This case has garnered so much attention there outside of Boston, but also really worldwide. And as the news of the verdict being reached started to spread, we saw the crowds gather. You could even hear the crowd roaring once the verdict came in. You could hear the cheers. We have Emily Aketa, who's posted outside the courthouse there. Emily, I can hear them still going on right now.
Yeah, absolutely. This is the verdict that this crowd of Karen Reed supporters had been hoping for, and you can see why police closed down the streets as soon as they heard word that there was a verdict that would be delivered. You can see them cheering. They're facing the courthouse, waiting for Karen Reed to walk out of the courthouse. There's been various family and friends of hers walking out that they have been cheering to along the way. There was emotion emotional. You could see on those screens inside the courtroom, but also outside as well. This has been the loudest this crowd has been since the start of this retrial, because they actually were ordered not to make any sounds. They weren't supposed to chant. They weren't supposed to cheer. And so while Karen Read has been going in and out of this courthouse, they have been silently showing their support with just showing this sign, I love you, the American Sign Language for I love you. But now you can hear the excitement. Right now they are chanting free Karen Read behind me. Just briefly talking to people, they say, okay, yes, she was charged with that much lesser charge of operating a vehicle under the influence, but they were worried about those top charges because of the minimum mandatory sentences that they could carry. This is what they had been hoping for. I've spoken with people who have flown from Michigan, who have flown from Florida to be here today, hoping that a verdict would be delivered. As you well know, Laura, it has been a long road to this point with a lot of legal twists. Even earlier today, at one point, the judge had reconvened court. They called back the prosecution. They called back the defense. And they said that the jury had knocked on the door earlier today saying that they had a verdict, but then a short time later knocked again and said they didn't have a verdict. So the judge ordered them to go back to the deliberation room and said that that verdict slip would be sealed. But then a very short time later, we got word that there was indeed a verdict, and they ruled not guilty on manslaughter while operating a vehicle under the influence, second-degree murder, the top charge, and fleeing the scene of an accident, a deadly accident, but then convicting her on the operating under an influence, which is an interesting note on that verdict slip, Laura, because that was not an option for the jury in the last trial, and it's something that the defense had pushed to add on the verdict slip this time. It seemed like it was a successful strategic move. On the ground here, we are now waiting to hear from Karen Read's defense team. She's been very vocal, as you well know, throughout this second trial. So we expect to hear from her on the steps behind, and you can see all of her supporters waiting with bated breath as well.
Emily, as we await to see what Read says, it's worth noting she has been very vocal throughout this entire trial in ways that you don't often see from defendants facing criminal charges, certainly people facing life behind bars. But she's addressed her supporters. Her supporters have almost become part of this case in so many ways. Emily, talk to me about sort of the larger way that this case has sort of tapped into the zeitgeist. There's been so much attention. There's been documentaries, streaming series. There is something about it that has captured the attention of so many.
Yeah, absolutely. And that attention around this case has grown since the first time. She's been very outspoken, as you mentioned, conducting numerous documentaries. She's done a whole host of TV interviews. Going in and out of the court, she would almost acknowledge the media almost every single day. So we constantly were hearing from Karen Read, though she didn't testify in the case. However, it is worth noting that those interviews did play a role in the prosecution trying to build their case. They played some of her interview clips, especially around the amount that she drank the night hours before John O'Keefe had died, and maybe that played a role in the jury's decision regarding that OUI charge. We don't know exactly what was said in the deliberation room, but it was also in one of the 4 questions that the jury posed to the judge yesterday. They asked, should those interview clips with Karen Read be considered evidence? And so that was one of the differences that we saw in this trial versus the first trial, Laura.
Yeah, one of the other things that strikes me, Emily, is the way that the defense and the prosecution had some lessons learned from the last time. If you think about it, the last time the prosecution was sprawling in its presentation, so many different witnesses, and this time they were much more surgical, they were much more focused on the data, they were much more focused on sort of the hard evidence, and they managed not to put on people on the stand that they knew could be potentially damning for them, and yet it wasn't enough to convict her this time around.
Yeah, that's right. I actually talked to a juror from the first trial, and he said that he felt like both presentations from the prosecution and the defense were much more streamlined. They presented stronger evidence, for example, the crash reconstruction demonstrations, than compared to the first one. He also had expressed that in that first trial, they largely unofficially agreed that they should acquit Karen Read of the second-degree murder, the first charge, and the third charge, fleeing the scene of a deadly accident, but that they were deadlocked on the second charge. This time around, the jury did indicate in a question that they were asking about, okay, well, what if we agree on 2 charges, but we don't agree on 1 charge? They also appeared to zero in their questioning on that second charge, a subcharge, the lesser charge of OUI. So there were questions around if that confusion remains. Could this lead to a repeat of last year? But it seems like they got the answer, or they were able to reach a unanimous verdict on all 3 counts, and here they are delivering their verdict.
Yeah, Emily, and at this point, you know, the prosecution has to be thinking whether they should have recharged her in the first place. They used the exact same charges. They didn't have to bring this again. They could have changed the charges in some way, or they could have just dropped this entirely. They've spent an enormous amount of money. If you think about it, they hire a well-known criminal defense attorney, someone who represented Whitey Bulger, notorious in Massachusetts, to serve as a sort of special prosecutor in this case, and has spent an enormous amount in trying to prosecute this woman who, as you can see there, has just legions of supporters who believe that she was framed. I mean, that's the core of this case, is that not only was there no collision, but that there was a massive conspiracy to try to frame her for something she didn't do.
Yeah, it's a good point, Laura. But I will point out that I think there are other people that I've talked to, a lot of people that did believe that she was guilty and should be held responsible. But this cohort behind me, especially loud in their voice, I guess it could be it was likely go down as one of the most expensive DUI cases, or OUI, operating under a vehicle under the influence of alcohol, perhaps in state history, since that is the conviction that she is walking away with, Laura.
All right, Emily, I appreciate your coverage. We're going to stand by there and wait to see if Karen Read comes out to speak to all of her supporters, which I imagine she will shortly, probably still wrapping up matters in the courthouse. Danny, I want to bring you back in here. This has been a long road for Karen Read and her defense attorney. What do you think was different this time around in terms of what they were able to do to convince this jury that she should be acquitted? Obviously, it's not their burden. We know that. We know as former defense attorneys, or me, former defense attorney, it is the prosecution's burden to convict beyond a reasonable doubt. And it's a high standard on purpose. But what do you think the defense was able to do to sort of plant those seeds of reasonable doubt this time around?
In a sense, the key difference goes to the word you just used, burden. And you're right, the defense has no burden to do anything. But commonly, a defense might decide, hey, we're going to put on a case of our own. We have our own theory. And in the first trial, that's exactly what they did. They went with a theory of conspiracy and cover-up, and they went with that hard. This time around, it felt more conservative. They didn't push the conspiracy theory nearly as much. Instead, their promise in their opening statement was this: there was no collision. That sends a message. Instead of proving an alternate theory that O'Keefe was beaten up or thrown out or everybody covered it up, which, by the way, they still explored through cross-examination. But instead of that, their theory was, look, the Commonwealth can't prove that there was a collision. They don't have enough evidence, and we have other evidence that casts reasonable doubt on the idea that there was a collision. And I believe that we can infer that the jury bought completely into that, because the conviction for OUI was the only conviction that they could find her guilty of without having a collision. In other words, they must have believed that there never was contact with, or at least there wasn't proof beyond a reasonable doubt of a collision, and they chose instead to find her guilty of OUI. And you saw in court, she turned to her attorneys when she heard guilty of OUI, and she had a look on her face, Karen Read, of like, that makes sense. It was part of their plan. They were all on board. They were hoping for a conviction only on OUI, and they got really everything they wanted.
It seems like the strategy of not placing blame directly on any one person as the alternate perpetrator, if you will, of this crime, right? They didn't get to actually name anyone by name to say, okay, that's the person who actually killed John O'Keefe. That's the person who actually did something to him in the house. They had this whole idea of the dog bites being the reason that his arms have all kinds of abrasions. They have lots of theories about why the dog gets rehoused. That was one of the biggest questions I had. Who rehouses their dog, right? The German Shepherd, Chloe, is taken out of the house mysteriously after John O'Keefe's death. But they didn't actually name anybody else. And it makes you think whether that was sort of a smart strategy, because then they weren't sort of wedded to any one theory, and allowed the jurors to say, we don't know what happened, but we know the state didn't prove that she actually intended to kill him, left him there for dead. And then, of course, they have all of her statements saying, I hit him, but it's all in the ball of confusion the morning after. And it seems that they were able to throw enough muck in all of that the jury said, I just can't convict her.
Yeah, and it goes back again to what you said earlier, that we don't, as the defense, we don't have to prove what happened at all. And commonly what we do is just throw up ideas of reasonable doubt. And the dog example is a perfect example. Consider this. Even if the dog bite wounds or the wounds on his arm were from a dog, those wounds didn't kill him. But you might wonder, well, why didn't the defense explain what actually killed him if they say there was a dog attack? They don't have to do that.
Yeah.
Instead, they just put that out in the ether. And they hope that in the jury room, at least one person is saying, hey, the Commonwealth told us those injuries to his arm were from hitting the car, but there's not enough proof of that. And instead, they've raised this whole dog theory. They don't have to prove that beyond a reasonable doubt. It's just something that casts reasonable doubt on the Commonwealth's case. And I think it did so very effectively. They had an expert come in and testify. I'm an expert. I'm very credentialed. I've written on the subject. I'm a genius. And these injuries were due to a dog bite. And often these cases come down to, as you know, a battle of the experts.
Yeah, we're still waiting to see Karen Read coming on the courthouse steps there. Imagine momentarily there in Dedham, Massachusetts. But, Danny, you know, as you were talking, it makes me wonder about, again, just sort of the strategy calls here. She did not take the stand.
Yes.
And we had wondered whether she would this time, in the hopes that she would think that she has to just sort of clean up, if you will, some of the things that she said in taped interviews with the media after the first trial, right? So after the first trial, all of these interviews come out. She spoke to Dateline, she spoke to others, and all of those get played for the jury. And we had, you know, had many conversations about whether she would have to take the stand to sort of try to explain some of that, or whether the jury would be left with all of these misimpressions. And they made the call, no, we don't need to call her to the stand. We don't need to take the risk of putting her on the stand and face cross-examination.
Karen Read had a constitutional right to take the stand and override her own attorneys. That being said, she was likely never, ever going to take the stand for a number of reasons. Number one, you generally shouldn't call your client, the defendant, unless that person has information that you really can't get from anywhere else. And what would Karen Read have taken the stand to do? Every indication is that she was so drunk she didn't remember what happened that night. Yeah. So what is she going to deny? And then in addition to that, you have to weigh, what do we get from putting our client on the stand against the damage she'll do? And she just had too many character problems. Yeah. This is somebody who was clearly drinking a lot on video, who was admittedly someone who shouldn't have been driving that night, who left maniacal-sounding voice messages on her boyfriend's answering machine, and was secretly texting one of her boyfriend's colleagues in a romantic way. All of these different things would have been very difficult for her to answer on the stand. Instead, the defense got in all the evidence they needed from other sources, and they took great pains to do that, and they avoided having to call their client. And surely Karen Read knew herself that she was never going to take the stand. In fact, that is likely why she felt more emboldened to speak to people in the media and to documentarians and people filming her, knowing that she wouldn't be subject to cross-examination and hoping some of that might find its way into court. And it did. The prosecution thought it was very good evidence for them, and to some degree it was. Make no mistake about it.
Oh, yeah.
All the things that Karen Read said, both at the scene and after, to people in the media, were not good for her. She was acquitted because of the Herculean efforts of her defense team, not for anything Karen Read did, either at the time, that night, or afterwards in talking to people.
Spoken like a true defense attorney. I just want to mention here, as we continue this live coverage of the Karen Read verdict, while we were chatting, the judge asked for a sentencing date for that one charge that she was actually convicted of. The prosecution said, let's go right now, Judge. We're ready for sentencing today, and recommended 1 year probation for that driving under the influence charge. The defense agreed, and the judge sentenced Read to 1 year probation. And so that is the only punishment she will face, again, for this entire episode, where, Danny, she had been facing the potential of life behind bars, and now instead just 1 year probation.
Exactly right. The statutory maximum for OUI for a first offender can be up to 2.5 years in prison, but the reality is, in Massachusetts, as in many states, number one, DUI first-time offenders usually get into some sort of probationary program, and they can even avoid the conviction. But in this case, it's not likely she was really she could have gotten some jail time, but 1 year probation is right in the zone for a first-time offender, especially where you don't have a breathalyzer, you don't have any information intoxication other than this retrograde analysis that they used to go backward in time and kind of guess that she was intoxicated. Again, the best evidence of her intoxication was Karen Reed's own words in a documentary video that was available to the government.
That's right. There really wasn't any other direct evidence of the sort on that. I want to go back to the courthouse in Dedham, Massachusetts, where Emily Aketa is outside the court there as we await to see Karen Reed on the courthouse steps, I imagine, just in moments from now. Emily, what are folks saying out there? What is the mood?
Well, it is pure elation as they continue to erupt into cheers throughout the last matter of minutes. You'll see in the distance there a sign, Justice for John O'Keefe, the police officer who died back in 2022. A lot of these supporters telling me that while they think Karen Reed should not be held accountable, that they believe she is innocent, they still want justice for John O'Keefe. Her father also echoing that to me the other day. He also had said, talking about the feeling inside the courtroom yesterday into deliberations, he said you could cut the emotion with a knife because there was so much riding on it, he said, for his family, that he just wants his daughter home and free, and that is exactly what will pan out after the courthouse today. I also want to read a statement to you from some of the people within John O'Keefe's family circle, their friends and family, some of the people who have been at the house party the night before John O'Keefe was found dead back in January of 2022. This is a statement from Jennifer McCabe, some of her family members, also from some of the Alberts, that says, "Today our hearts are with John and the entire O'Keefe family. They have suffered through so much and deserved better from our justice system. While we may have more to say in the future, today we mourn with John's family and lament the cruel reality that this prosecution was infected by lies and conspiracy theories spread by Karen Reed, her defense team, and some in the media. The result is a devastating miscarriage of justice." So while there's this feeling of elation on the ground outside of court, you know, for some it is a much more somber and serious tone, Laura.
Yeah, well, that is one of the sort of sad realities of this case, is while Karen Reed has been acquitted of the most serious charge there of second-degree murder for the killing of John O'Keefe, we may never know exactly how John O'Keefe died. The defense in the first trial offered a sort of a number of theories and conjecture, but there's been no direct evidence, and there's been no suggestion, Emily, that the police are in any way going to now open a new investigation as to how he died.
Yeah, that's right. And you really feel for John O'Keefe's family. We've watched his mother and other families walk in and out of this courthouse for the last matter of weeks, sitting through hours of testimony. Remember, there was nearly 2 months of testimony from dozens of different witnesses, and some of it hard to watch, hard to hear. There were visuals, there were videos, there was this deep description about John O'Keefe's injuries, and so it has been an emotional ride for the family. In this retrial, we actually saw Peggy O'Keefe, the mother of John O'Keefe, take the stand, and she got emotional on the stand. You can imagine a painful past few years for the O'Keefe family.
Emily, what are people chanting behind you? You can see how tight the security there is. Is the mood tense right now?
They're chanting a number of different things. I can't quite make out this one. It sounds like someone needs to go, but they've specifically targeted some of the politicians, the investigators in various chants, also celebrating Karen Reed as well. And it's been coming in waves depending on who's coming out of the courthouse, who's passing by, or just kind of this in unison in this energy, while all awaiting Karen Reed to come out that courthouse door right there.
Yeah, it's worth noting that, and you know this so well, Emily, the lead investigator gets fired for misconduct in this case, which is so rare. I mean, he had sent a number of damning text messages about Karen Reed, explicit text messages that he exchanged with his buddies. He didn't testify this time around, but one of his friends did, and was forced to have all of that read aloud, which you wonder if it had any effect on this jury.
Yeah, definitely. I think the fact that he was fired was a really interesting dynamic coming into this second trial, the retrial, because it happened earlier this year. In that first trial, those texts really came to light, really crude texts that he had sent during the investigation about Karen Reed. And then after a state police review, they decided to fire him earlier this year. And it is something that the defense really leaned into, asking why didn't the prosecution call their lead investigator to the stand, because he didn't take the stand this time around, along with a number of other people that we saw didn't take the stand this time around. But Michael Proctor was certainly one worth noting, Laura.
Yeah, it's so interesting how some of these guys have become almost household names there, Emily, like Michael Proctor and, you know, Brian Albert and all of the other casted characters. This case has such a tangled web of different people that have sort of been involved in this from the very beginning. As you've been talking to folks out there, as you've been on jury watch for the past several days, Emily, are people dialed in, you know, in the way that we might imagine? It seems as if they're following every last detail. I mean, if you just take a look online, people have any number of different theories. They seem to have gone down the rabbit hole on this case.
Yeah, absolutely. It's a great example of America's true crime obsession. I just talked to someone a short time ago who said they were recently vacationing in Portugal, and yet she was listening through her AirPod as they were walking around castles to the case. Because remember, it has been live streamed from inside the courthouse. So many people across the country and to that point around the world have been following so very closely to this case. And you also look at the wide range of people that had taken the stand. Some of the people out here today, but then also that one juror I have brought up before who was on the jury last year that said one of the really effective experts that the defense had called to the stand was the ARCA experts, the crash reconstruction experts that had done this demonstration, a reconstruction of the alleged collision showing a dummy and the impacts to the injuries to the arm, to the body, if a vehicle had reversed into that dummy at various speeds, including 24 miles an hour, which is one of the speeds that the prosecution had suggested. Many people saying that they were much more impressed with the experts from that standpoint from the defense's side, because the prosecution had also brought forward reconstruction experts as well, and they contradicted each other. But people out here today and the juror that I had talked to really listening closely to those ARCA investigators, crash reconstruction experts, Laura.
Yeah, and the data figured in such a big way in this case, in some ways even more than the last time around. Again, you wonder if sort of lessons learned, Emily, and whether both the prosecution and the defense sort of had to tailor their case to meet the moment, knowing what happened with that mistrial last time. If you're just tuning in right now, we are following breaking news out of Massachusetts. You can see there where Karen Reed has been officially cleared, been found not guilty of second-degree murder, the most serious charge that she had been facing in this closely watched retrial. Reed was accused of killing her boyfriend, a veteran Boston police officer, by backing her SUV into him, leaving him for dead after a night of heavy drinking. She had maintained her innocence all along, said that there was no collision, and today she was acquitted on 2 lesser charges as well: motor vehicle manslaughter while driving under the influence and leaving the scene of a collision. She has now avoided what could have put her behind bars for life. However, she was convicted for operating a motor vehicle under the influence of liquor, as she had admitted to drinking that night, and she was sentenced right there on the spot, guys, to 1 year of probation. This was the moment when the verdict was read.
Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you? No. Do you agree? Yes. Do all of you agree? Yes. Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Is not guilty or guilty of that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
Yes.
003, what say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty?
Not guilty.
So say you, Mr. Foreman? So say you all?
Yes.
Jurors, hearken your verdict as the court records that you, upon your oath, say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be
That was
seated.
when the verdict was read, and as we wait to see if Karen Reid will speak when she leaves the courthouse, let's bring back our NBC News legal analyst, Danny Savalas, who has been with me as we have been watching and waiting to see what Reid says. She has been very vocal throughout this trial, Danny, and if I was to guess, as a criminal defense attorney, you would normally say, please don't speak to anybody during a trial. Please don't speak to the media. And sure, you have supporters, but please just keep your mouth shut. But she didn't. And she had a different strategy. She knew she had, again, legions of supporters out there every day. And it seemed to me, not to say that she was sort of playing that up, but that she felt that it was in her interest to maintain that sort of bond with her supporters throughout this trial.
There is a time-honored tradition between lawyer and client where the lawyer tells the client, first, don't talk to anyone, don't make any statements. And then the second part of that is the client says, yeah, I'm going to do this my way. And they're going to go and do whatever they're going to do, and you can't stop them. And I have to say, yes, she was acquitted. This is essentially a huge victory for the defense. But I have to wonder, if Karen Reid hadn't given those statements, if she hadn't said things like, hey, I probably shouldn't have been driving that night, if she hadn't given those statements at the scene of the crime, did I hit him or I hit him, would this have been an easier case? She might have even been acquitted on the OUI, although there was some scientific evidence introduced. They did do some testing later on in the morning. However, you have to wonder, did she even have a shot at the OUI? But candidly, the OUI was a good strategy because it gave the jury something to punish her for, because there was evidence of that, and they could differentiate that. They could still find no collision, but convict on the OUI. They never needed a collision to convict on the drinking and driving charge.
Something that they didn't have the benefit of last time around when she was first facing that trial. Looking at the fact that they only convicted her of that makes me also wonder if the jury just said, look, everybody was drinking that night. No one really has any clue what happened. Yes, right. She's on tape saying, maybe I hit him. I don't know if I hit him. But really, they don't have a single witness who could testify credibly about what did happen that night. They don't have a witness who says they saw her. They don't have a witness who says she confessed to me. They don't have a witness who had, a tape of her doing anything. All they really had was experts who maybe canceled themselves out.
Yes, and even the eyewitnesses that they did have, you could argue, were good for the defense. At least one eyewitness said, hey, I pulled up and I remember seeing just Karen Reid sitting in the car and not John O'Keefe. She was alone in the car. That tends to show that O'Keefe was out of the car and maybe even in the house. One of the defense's theories, and we talked a little about this earlier, again, the defense didn't need to develop any of these theories because any one of them a juror could have seized upon. Maybe one juror thought the dog evidence was compelling. Maybe another juror thought that the Commonwealth just didn't have enough information. There wasn't enough eyewitness testimony. And the technical scientific data they had, for example, they had data showing that the car had backed up a considerable amount at a decent speed, but it didn't register a collision because the system wouldn't recognize someone of O'Keefe's size. It would recognize colliding with another car, but not a 200-pound man. So the jury might have gone in there and said, I don't even care about the dog. They didn't have enough evidence to show the collision. There you see Karen Reid coming out now.
Yeah, you can see her there with her attorneys, Alan Jackson, and surrounded by her lawyers. She's putting up the sign for her supporters right now. Wait to see whether she comes to speak, as she has almost every day. She's had at least a few words for her supporters that have gathered there and for reporters, sometimes even previewing which witnesses were coming which days. She would give a preview of when things were likely to wrap. And so you can see her stepping up to the podium here now as the cheers and the roars from her supporters who have been gathered out there. Let's listen.
Say two things. Number one is I could not be standing here without these amazing supporters who have supported me and my team financially and, more importantly, emotionally for almost 4 years. And the second thing I want to say is no one has fought harder for justice for John O'Keefe than I have and my team. Thank you.
So you want to see it reopened? Karen, you want to see the case reopened? Should the case be reopened? No, the case cannot be reopened. Alan, this case is over. No, I mean, the case is largely for someone else. What did this say? What did it say about justice? I'm going to leave it. I'm going to leave it to Karen and her dad. Her dad has a comment. Let her dad make the comment. Mr. O'Keefe, what did you say about justice? Mr. Reid, I just want to acknowledge the strength of our daughter, Karen, the support of the entire Reed extended family. I want to acknowledge the greatest team of attorneys. Our first one that we found was David Yannetti. We added Alan Jackson and Liza Little. Bob Alessi, you know about. All right? It was a fantastic team, but we needed them all to defeat this. We thank everybody for their support from the heart. We love you all of the content providers who help spread the word. Thank you so much. God bless you all.
Investigation.
Let's do this.
And you can see Karen Reed leaving the courthouse there, led by security, a heavy presence of security there, as the courthouse is just sort of swarming now with supporters and security and other gatherers who have been following this case from the very beginning. She thanked her team. Emily, I want to bring you back in here, who's been posted outside the court. Emily, it was interesting to hear her say, no one has fought harder for justice for John O'Keefe than I have.
Yeah, and in a way that echoes what some of her supporters have said as well. But I thought it was really interesting that the very first thing she did after found not guilty on really serious charges, when she walked out these steps and she's addressing the media, that she thanked her supporters. Many of these people have been watching, as we well know, every single day in court, but also coming outside of the court, waiting for this verdict in person. You can see they're starting to disperse now. There are a lot of hugs. There's a lot of pumping of the arms. We also heard briefly from her father, who also thanked Karen Reed's supporters and the team of lawyers. It was a team of lawyers that had worked and presented various evidence over the past nearly 2 months throughout the trial, coming in and out of the courthouse. They have repeatedly held up this sign, "I love you," to the supporters, which was also offered by the supporters back to them. Again, going back to, it's been very quiet as they typically enter the courthouse, but now in another moment, we're hearing those cheers and cries for so many of these people wearing pink, of course, Karen Reed's favorite color, Laura.
Yeah, and you heard a reporter, I think, trying to shout to Alan Jackson about whether the case would be reopened, and he said no. And I think what he meant was that she can't be recharged now that she's been acquitted of these charges, especially second-degree murder. But maybe I think the reporter was actually suggesting whether the case of John O'Keefe's death could be reopened and reinvestigated. As you and I were talking about before, there's a question mark still out there about what really happened to him.
Yeah, there is that question mark, and one of the statements, or at least reaction, we're still waiting for at this hour is from John O'Keefe's family, with no one to blame for his death, with so many questions around what actually happened in January of 2022. His body was found in the early hours, a dark morning amidst a snowstorm, and now, as it stands, there are even more questions, it seems, around this, as we await to hear what the O'Keefe family will say in light of this recent verdict.
Yeah, and we'll see if any more fallout for some of the investigators who had been in charge of that from the very beginning. Emily, thank you for your coverage. We know you have been there for days on Verdict Watch, and all of your reporting has been excellent as usual. Thank you. Come back to us if anything further comes outside the courthouse. Danny, I want to bring you in because it strikes me, Karen Reed is not a celebrity. She was a former finance person. She was a former professor. She is not a politician. She is not a celebrity. And yet you look at the crowd out there, and she has garnered celebrity-like attention.
And it's astonishing to me, and I'll tell you why. I am surprised that this is someone who has rallied so much support, because this is someone who the facts indicated was driving around in her Lexus SUV, intoxicated after several drinks, and was also texting in a romantic way her boyfriend's colleague on the ATF. All of this information came in as evidence. So it has always surprised me that Karen Reed has become this cause celeb. However, what I think the greater message is that a lot of folks found that no matter who the person is, and as a criminal defense attorneys often have clients who do not inspire the public very much,
you
to
always
say
say
the
you
least.
don't pick your clients.
You don't pick your clients. And, you know, if people believe there was a cover-up, if they believe there was some conspiracy, it really shouldn't matter the character of the defendant if that defendant is being framed. A wrongful conviction is a wrongful conviction no matter what. So while it always surprised me that Karen Reed had so many supporters, given her the facts and evidence in this case, at the same time, those supporters may have seen this as an example of a cover-up and a frame.
Well, that's what you wonder, is if she almost became sort of a stand-in for people that think that there are root problems within the system and criminal justice system, and certainly all of the allegations of police bungling this from top to bottom, and all of the sort of unforced errors that the defense was able to say, look, this doesn't make sense. This was mishandled. Look at the text messages, right? The text messages that the lead investigators are exchanging about her are really damning.
I'm so glad you brought that up. That was the example I was going to give, because no matter what you think of a defendant, no defendant should have the lead investigator arriving at conclusions within hours of getting on the case and concluding, number one, that the other people involved are cops, so they're in the clear, and number two, that this person is going down just hours into the investigation, and to say nothing of the nasty things that he said about Karen Reed in his text messages, commenting on her appearance, commenting on her medical conditions, commenting also that he's going through her phone and telling his supervisor, I'm going through her phone, her download, and no nudes yet. That was one of the other pieces of evidence that came in. He was fired for his conduct on this case, and the defense had a brilliant point in their closing that the state troopers did not trust Michael Proctor. Why should you? He doesn't even work for them anymore. And I believe the Commonwealth may have made a misstep by choosing not to call him. They should have owned it more, and their theme should have been, look,
you think they should have put him on the stand, even with all of his awful text messages?
It's so easy for me to Monday morning quarterback this now, but I believe that at the time, what they tried to do was pretend Trooper Proctor didn't even exist, that he was not the lead investigator. They wanted to call him something else, the case agent, and they called his supervisor. But the problem is the supervisor barely did anything hands-on on the case. So,
and his own friend says, I don't want to read this stuff in open court. If his own friend says this stuff is so bad, I don't even feel comfortable reading it, what's the jury supposed to do with that?
Right, and I have to wonder, maybe we'll find out, was the jury in there saying, why were they hiding the lead investigator from us? Okay, he was fired. Let him come in and explain it. But again, it's very easy for someone like me with no stake to come in. This was a calculated risk the prosecution took, and it was actually probably a wise one at the time, given that if they didn't call him, maybe the defense would be forced to call him, but they never were going to call him, because if they'd called Trooper Proctor, he would have been able to humanize himself, explain what he did, apologize, and maybe even seem sympathetic. Interestingly enough, neither side wanted to hear from the lead prosecutor who had been terminated in
Which just gives the defense an easy layup to say, why is he not here? Why haven't you heard from him? Now, of course, all of that stuff is just fodder for closing arguments, and they used it in openings as well. They said, let me just tell you how rare it is to have a state trooper, a lead investigator like this fired. This does not happen, folks, and it may be that resonated with this jury. Maybe that this is a jury in Massachusetts that said, look, you know what? We're fed up with this type of misconduct, and we want to send a message. Again, we don't know. We weren't in the jury room as much as we wish that we were. We're obviously going to wait to see what some of the jurors say. Obviously, it's always fascinating once this kind of thing happens to sort of do a debrief with the jurors and see what really resonated with them. And a number of them, which in a rare move, again, one of them actually served on the defense team this time around, sort of providing a little bit of color and commentary, which, again, you don't say.
We thank you for watching, and remember, stay updated on breaking news and top stories on the NBC News app or watch live on our YouTube channel.